Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
Next is a summary of federal and state statutory laws. Why? Again, we're going to talk a little bit more about why is it important to prevent sexual harassment in the workplace. First of all, it does harm everyone in the workplace. As we talked about already, it affects bystanders and witnesses, it affects patrons, it affects customers, it affects contractors, it affects employees, even supervisors. It can be the other way around too. So overall, everyone in the workplace will know that it's happening in some way or another, whether they feel it in their gut or otherwise. So if you take steps to try to prevent this or make a work environment that's welcoming and that people feel comfortable talking to you about things like this, that if they feel uncomfortable about something, this is always in your best interest as an employer. It also shows that you are willing and able to treat employees with respect and dignity, no matter what their walk of life is, who they are, what their religion is, anything. So that will encourage, that's good for business because it will attract talent, as we talked about before. It's just a very good thing to do as a business owner. It also, you have to comply with the law, the Civil Rights Act of the Title VII of the Civil Rights Act and the Illinois Department of Human Rights Act. And it could reduce but not eliminate your liability if something should happen in the workplace. You have documented that you took steps to create an environment, to train them what not to do. That will help your case if, unfortunately, it does go to suit. Also, supervisors and managers and officers of the company can also be personally liable for damages if they knew or should have known that this was happening. If somebody tells you and you ignore it, if you think something's happening and you don't say, hey, are you okay? Are you okay, Rob? Are you okay? What's going on? If you knew or should have known and did not do anything about it, yes, you could be personally liable. All right, what can I do? Well, now put yourself in the employee's shoe, or even if you're being harassed as an employer or owner of a business. What can you do? How to report sexual harassment. The first thing is you can call the helpline for the Illinois Sexual Harassment and Discrimination. They also have a website. Now this is part of the act this was set up. It's not the Illinois Department of Human Rights. It is like a separate entity for reporting, and I've never had a case go through this entity before, but I would assume at this point that they would refer you or help you fill out a complaint form with the Illinois Department of Human Rights or the EEOC. There's the number and the hotline and the website. You can report, as I said, the first step to this is you can report this to your employer. How would you do this? First of all, you have a couple options. You can go to your supervisor if you have one, if that person is not the perpetrator. If that person is a perpetrator or you don't feel comfortable talking to your supervisor, you can go to your HR person or designated officer that's responsible for this. And something that's not real clear in the state mandated training is that in the important first step for having a safe, welcoming work environment that's free from harassment and bullying, etc., is to have a solid policy in place. So if you have a sexual discrimination policy in your handbook or that you give to your employees, then that should spell out exactly what steps to take if they have an issue or incident. Okay, the next step, if things aren't resolved, you can file a complaint with the Illinois Department of Human Rights. And what that includes, the Illinois Department of Human Rights is the responsible state agency for enforcing the new statute for sexual harassment prevention training, which now includes only one employers. And they also, their requirements are that within 300 days of the alleged incident, the harassed individual has to report. However, if they have kind of an ongoing thing, like it happened last year, it happened 2 months later, it happened again 6 months later, so that gets a little loose, but whatever the last incident that they are aware of or that happened, they have 300 days to file a complaint. And this jurisdiction of one or more employees, and when someone files with the Illinois Department of Human Rights, it also co-files with the EEOC. So automatically it does. Remedies with the state could include an Illinois Department of Human Rights investigation, and then once that is complete, whether they find substantial evidence, they can give a right to sue letter. But more often than not, they don't have enough staff to do all of the investigations. So they may wait a period of time. They max out their 6 months, I think, and at the end of that, if they haven't been able to investigate, they will automatically give a right to sue letter. Now, what does that mean for you as an employer? It means that they can now file in civil court, and that gets expensive. But unfortunately, that's generally the default right now because they just don't have the staff to do the investigations. If they do take on the case, they will conduct an investigation, they will expect discovery, they will talk to all the witnesses just like you would an internal investigation, and they will try and get you to settle with the party. And that could include make whole, which means back pay, lost benefits. You have to clean their personnel file. You might have to reinstate them. You might have to fire someone. You might have to reorganize your structure so they don't work in the same department anymore. And it also could include attorney's fees and costs for the claimant. So it can get pricey whether it's settled or whether it goes to court. Now, last but not least, they can also file with the EEOC. That's the Equal Employment Opportunity Commission. They govern the Title VII of the Civil Rights Act and all its amendments. Okay, sorry. Equal Employment Opportunity Commission. They are the responsible federal agency. They also have a 300-day limit of filing alleged incidences. They, of course, they are responsible for employers of 15 or more. So anything smaller than 15, they will not co-handle. But anything 15 or more, they will co-handle. If they take the case, then the Illinois Department of Human Rights does not do the investigation. The EEOC does. And if the EEOC gets involved, that's a big deal. That's a big deal. It's a little scary, but get to your attorney, they'll help you. It's not automatically filed with the Illinois, if somebody goes directly to the EEOC, it's not necessarily automatically filed with the Department of Human Rights. So it's another difference. Potential remedies with the EEOC are same thing. They will conduct their investigation, they'll talk to witnesses, etc. And of course, even if they find, they will have a letter from an administrative law judge, correct? They still use ALJs. And it will either say, yes, we find substantial evidence, or no, we do not. And I'm not sure what happens after, if you get a no, but if you get a yes, they will try to settle it as well, or they will get a right to sue letter, and you can also, they can file in the civil courts. The potential remedies are pretty much the same, but more expensive. If they find substantial evidence, then you can back pay, lost benefits, personnel file, everything I said before, same thing goes. You have that risk. And again, don't forget that potential personal liability, if you knew or should have known as an employer or supervisor, that means they can go after you personally.
Thank you again for watching this informative session. If you have any questions about what you just heard, or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.